Okay. Good afternoon. My name is Matt Parker, and I want to welcome you to the webinar on the new veterans rules that will affect the veterans benefit known as aid and attendance. We'll be touching on the new net worth limitation, the look-back period for any gifts that might be made, and the transfer penalties. Now, my law firm has done a webinar in the past about aid and attendance, but this webinar is intended as an introduction to these new rules for applicants. Keep in mind that these new rules were intended to be rolled out on October 18th of 2018. As I'm doing this webinar, that would be tomorrow. So we're going to talk about whether these new rules are actually going to be rolled out tomorrow or whether it's going to be business as usual until the Veterans Administration works out some of the details behind these new rules. Also keep in mind that there are some rule changes that we are not going to review. There are quite a few of them that were rolled out by the Veterans Administration, and I cannot cover all of them in 30 minutes. I will cover those that typically come up in the average application for aid and attendance benefits that affect our elderly population. So if you are involved in assisted living facilities or otherwise, these are the rules that you need to be aware of if you're going to assist somebody going forward with an application. If you want more information, and I'm not covering all the details, I recommend you get online and you look up the Federal Register. That's where these new rules were published. So you go to the Federal Register at volume 83, number 181, and that was published a month ago on September 18th. Page number 47246 if you need that, but I think if you just type in Federal Register Veterans Rules, volume 83, number 181, it will pop up, and then you can print it out. It's a 10-page or so discussion of the new rules and why they made the new rules and the various comments that were made during the process. So go ahead and look at those if you want all of the details about the new rules that are coming out. So with that, let's get started. Now, I'm just going to go over a little bit of the background behind what is aid and attendance, because there may be some people who are consumers listening in and they want a little bit of information about this benefit and how it might help their loved one. This is a pension benefit. It is a monthly amount of money that is paid to some of our veterans. It is one of 3 pension benefits for veterans who have low income and is primarily intended to help pay for care at home or in an assisted living facility or a personal care home. As I go through the materials here, I might say assisted living. That could mean personal care as well. It's not necessarily the actual assisted living facility we have here in Pennsylvania. So the aid and attendance benefit is the highest level of improved pension that's available to our veterans. In order to qualify, a veteran, or in fact, a widow of a veteran, needs to document the need for the regular aid and attendance of another person. In other words, they need help. So there are several ways to establish this need for the aid and attendance. Typically, the veteran requires the aid of another to perform what they call the activities of daily living. That would be bathing, feeding, dressing, toileting, and so forth. Sometimes the veteran is simply bedridden because of a disability. They could also be a patient in a nursing home due to some mental or physical incapacity. And lastly, the veteran could be legally blind. Any one of these conditions could arise, justifying the need for an additional amount of money every month to help pay for the cost of the veteran's care. And of course, that benefit is called aid and attendance. Oh, and this slide, by the way, shows the maximum amount you can receive every month. It's currently $21.69, but that would be with a dependent at home. That $21.69 we're going to talk about later in the presentation and how that plays into the penalty that can now be assessed if you give away resources in an attempt to qualify for aid and attendance. But not everybody is going to get the $21.69. It will vary from applicant to applicant. All right, so these are some of the general eligibility requirements for the pension benefit, including aid and attendance. The veteran has to serve at least 1 day during what they call a wartime period. I don't have the actual dates on the slide, but you can visit the Veterans Affairs website and see the actual time frames for these various conflicts. For example, the Second World War, the Korean conflict, those that fought during the Vietnam era and currently the Gulf War. I believe the time frame for the Gulf War began in 1990, and it's still going on right now. So all of those individuals are covered by the Gulf War. So there are time frames that you have to actually serve 1 day during those periods. The veteran has to be discharged from the military other than dishonorably, and they have to have at least served 90 days, as I mentioned, with 1 day during one of those wartime periods. There's no requirement that the veteran was on the battlefield. You didn't have to be over in Europe or some field of battle. You could have been serving stateside. The veteran will need his or her discharge papers, and that's called the DD 214, to prove the dates of your service and the type of your discharge. Beyond that, there are these tests that have to be made. You can see on this slide there are 3 of them. There's the medical needs test, there's the asset test, and there's the income test. We're going to talk a little bit about these tests, as well as the brand new test about transfers, which is kind of associated with the asset test. So we're going to get into all 3 of those today. The one that has I would say the limited change to it is the medical needs test. There is still an evaluation done by the veteran to determine if they are in need of aid and attendance benefits. We're going to talk a bit about the clarification in the rules as to what types of needs will be covered. Not all individuals, for example, who are in an assisted living or personal care home may receive aid and attendance. What the Veterans Administration is doing is making sure that those individuals who are in one of these facilities need help with the activities of daily living. And they did go so far as to define those in the new rules so that you have some clarification as to what types of activities are covered, what type of activities are not covered. If you read the comments in the Federal Register, you can see the Veterans Administration does not want to be handing out aid and attendance to just everybody who might be in an assisted living facility or everybody who might be getting some form of care at home. They want to cut down on the number of individuals who are actually receiving these services. So they're going to have a closer examination, if you will, of those individuals to make sure they are, in fact, in need of aid and attendance to help with what they call custodial care, and it's defined by these activities of daily living. Here is the first of the several financial tests. It is called the income test. Generally speaking, a veteran's income has to be less than what is known as the maximum annual pension rate. They call that MAPR. Now, the income applicable to each veteran, as I mentioned, is going to vary. Depends on his or her medical status and whether they have dependents at home. So if you're married, you get more money than somebody who might be single. The income limit is increased if, of course, the veteran is in need of aid and attendance. There are other pension benefits out there that don't pay as much as the aid and attendance benefits. So this is, as I mentioned, the highest pension benefit available. All of the applicant's household income is counted. So they count all of the income coming into the household unless there's an exclusion of the income. It's all going to be added up. Okay? Now you can reduce your income through what are called unreimbursed medical expenses. So we're going to talk about how those expenses could drop your income level, and suddenly by reducing those expenses, you will then be eligible for an income analysis. Here are some of the examples of the excluded income. Some of these are logical, your welfare benefits, income tax refunds, and so on. These are not counted when they add up all of the income sources in the household. When I've seen applicants, normally it's the Social Security and the pension benefit that we're really looking at that comprise most of the income sources that are added up to determine if you are eligible. Well, even with the exclusions, many of our veterans, if you just counted up all the gross income, it would be too high to qualify for the VA pension, okay? So a veteran whose income is above the income limit, that maximum limit I talked about, may still be able to qualify for a VA pension by taking deductions that reduce the amount of income that you have coming into the household. So typically what will happen is you'll have all these unreimbursed medical expenses that can be deducted. And on this slide are the most common ones. You have out-of-pocket expenses, for example, if the veteran or spouse is paying out of pocket. They're not being reimbursed by any insurance company for those expenses. They have to pay them out of pocket. There's medical insurance premiums, whether it be for Medicare or a private insurance policy, let's say supplemental insurance. There are fees that might be paid for care. You might be in an assisted living facility and you need help with custodial care, and you might get those expenses reduced or actually deducted from your income. Other expenses would include dental services. In-home care, you might be paying a caregiver out of pocket, and again, if you need help with the activities of daily living, those expenses can be deducted. Any medical equipment you could be buying, hearing aids, wheelchairs, and so forth. Those are also deductible as well. Now, some of the new rules, if you read through them, they're going to restrict and clarify what can be used as an unreimbursed medical expense. These rules are defining the activities of daily living as basic self-care activities, and they again consist of bathing or showering, dressing, eating, toileting, and transferring. Assistance with any two of those activities would be necessary to qualify for custodial care. So whether you're in an assisted living facility or you're back at home, you've got to be having assistance with at least two of those activities: bathing or showering, dressing, eating, toileting, and transferring. The import of these new rules is that not all the charges, for example, in an assisted living facility, would necessarily constitute an unreimbursed medical expense. There has been a system in the past where you've had to go through to determine if, in fact, you're providing the sort of care that ordinarily would be needed to help with those activities of daily living. There's something called a fast letter and so on. All of that, if you read the rules, is still there. So if you're from an assisted living facility and listening in, there is guidance in these rules as to how you go about confirming that the person who is in your facility is still getting the sort of custodial care that would be covered under the aid and attendance rules. They do make a point of clarifying that there are activities that are not going to be covered. So instrumental activities of daily living. So you see those abbreviations on this slide, ADLs versus IADLs. They make a big point of clarifying between these two types of activities. IADLs are not going to be covered. So independent living activities such as shopping, food preparation, housekeeping, laundering, managing finances, handling medications, using the telephone, transportation for non-medical purposes, all of those are not going to be covered. So a lot of times in assisted living, there's a mix of these services being provided. You're going to have to make sure that the ADLs are in fact being provided to your residents. There's also going to be new restrictions for the reimbursement rates for home-based services. The VA is going to clarify its policy with respect to in-home attendance and limit the hourly rate that the VA would consider deductible. The VA says that it's to minimize incidents of fraudulent or excessive in-home care charges. The VA is going to basically require that the hourly rate for in-home care has to be reasonable and derived from a reputable industry source. And again, read the Federal Register and you can see what they're talking about when they talk about an industry source. All right, one of the two biggest changes to the rules includes a change to the asset test for aid and attendance benefits. So when determining eligibility for pension benefits, the VA takes into account assets owned by the veteran and the veteran's spouse. They will deny the application for benefits if the veteran has in excess of a countable asset limit. So in the past, the figure was not set forth in any rule or regulation, but it was generally regarded as being $80,000. The new rules have a bright line test for countable assets. This is actually one of the better parts of the rules, if you want to look at it that way. And they now call this a net worth of the applicant, and the figure is the same as the standard maximum community allowance for Medicaid applications for long-term care. So you ever see the abbreviation CSRA, CSRA, it stands for Community Spouse Resource Allowance, and right now the maximum is $123,600. So the veterans are allowed to have that much money and be eligible for aid and attendance. Now, to arrive at this figure, what you have to do is count up all of the countable assets. Most of the time, that's the liquid assets, the bank accounts, CDs, investments, annuities, retirement accounts, cash value of life insurance. One of the big changes is that they now are going to count 1 year's worth of the income of the applicant. So you take the gross income of the applicant over the course of the year, that is going to be counted as part of the resources of the individual applying for medical assistance. Doesn't really make a lot of sense if you think about it. Income is separate from, let's say, your savings. Why should the income be considered assets? But the Veteran Administration has says 1 year's worth of annual income is added to the total of your other assets to determine if you meet the net worth limitation. So what if you've got somebody who has too much money, in essence? They have more than the net worth limitation. How do they get their resources down? Well, I've already talked about one of them. You have to reduce your income, first of all, through unreimbursed medical expenses. You have to have some expense, ongoing expense, typically assisted living or caregiver expenses that are greatly reducing this figure. Spending down on excess resources is also permitted, but they're telling us that essentially if you want to spend down your money, you're going to have to spend it on basic living expenses. There's also a provision for education or vocational rehab. I think that's for younger individuals, quite frankly, but for elderly individuals, you have to be spending your money on basic living expenses to reduce your asset level. Unlike in the Medicaid context, where you might be able to go out and buy a new car to reduce your resources, the VA rules don't read like that. It's not something that they're going to allow you just to shelter your money on perhaps items that you don't really need. Brand new TV. It does not appear that the rules are set up to permit that. They define those expenditures as basic living expenses, things you actually need to live on, not luxury items. So, net worth or countable asset determinations will no longer take into account, for example, the life expectancy of the person applying, the rate of depletion of assets, or any other factors. Those have bounced around for many years as to whether or not those are used to determine how much money or resources you can have. And there is much more of a bright line test now, so it's consistent from applicant to an applicant. Well, the exempt assets, the assets they don't count when you apply for aid and attendance, have included the principal residence, the household goods, the motor vehicles, particularly if they're used for transportation of the veteran and the dependents. However, there's this brand new and somewhat troubling restriction on the exemption of the residence. And this could prevent a lot of our veterans from obtaining the aid and attendance benefit. Now, the new rule provides that the VA will exempt the primary residence, but only if the residence and the land around the residence, they call it the lot, does not exceed 2 acres. Now, the 2-acre limitation is what has concerned many of our practitioners, particularly those folks in rural areas where there are relatively poor veterans who have a home on more than 2 acres. Now, there are provisions in the rules for the applicant to claim that the additional acreage is not marketable, but it's really unclear as to how this is going to be applied in applications. Can you just walk in there and say, I have 2.5 acres, and nobody's going to buy my half acre? It's ridiculous. You know, who's going to come along and buy the half acres between me and the neighbor? How are you going to deny me aid and attendance because of that? This is an area that really has to play itself out, and we're going to have to see how the Veterans Administration is going to deal with this new rule. It has nothing to do with the value of your house. It has everything to do with the acreage, the amount of land that you have around your residence. Other rules with regard to the home, it says that if the residence is sold, the proceeds of the sale are going to be countable unless the proceeds are used to purchase another residence within 1 calendar year of the sale. Now, Veterans Administration is not going to include the primary residence as an asset, even if the resident resides in another facility, like an assisted living or a nursing home. So it's much like medical assistance, where they don't, make you sell your home if you have to relocate to another environment. There are some other environments that you could also relocate to. I believe if you're living with a relative and they're caring for you, that's also a scenario where they won't make you sell your home. So it is an exempt asset. The acreage situation is a problem. As we read these new rules, keep in mind these are brand new, scheduled to be rolled out tomorrow. We're not quite sure how they're going to deal with this 2-acre limitation. Now, in the past, the VA did not impose a penalty for gifting assets to reduce your net worth. So an applicant could transfer assets the day before applying for benefits and could get eligibility so long as the assets were then below the countable limit. Now, for new applications, the Veterans Administration is entitled to look back 3 years to determine if any assets were transferred for less than fair market value. That is, you didn't sell something and get cash for it. You just gave it away and did not get anything of value in return. If the Veterans Administration does learn that you made a transfer, they can impose a penalty, or what's called a period of ineligibility for the aid and attendance benefits. So absent any clear and convincing evidence showing otherwise, the VA is going to presume that the asset transfers were made, any asset transfers that were made during the look-back period were in fact done to establish eligibility for the pension benefit. They'll just presume you did it to try and get the pension. It's very similar to Medicaid, by the way. It's not an unusual rule. You would have to come forward and say, listen, I didn't need the pension 2 years ago. I gave $5,000 to my son for this purpose or that purpose, and nothing to do with trying to shelter assets. You would have to rebut the presumption. Now, the changes, of course, as I mentioned, would establish a 36-month look-back period, and there would be a limit on the number of years you could be ineligible due to a transfer of resources, and that is, in fact, 5 years. So there's a 5-year limitation on the number of years you would be eligible due to a transfer. Now, the transfers will include any transfer to a person or to a trust. We're going to talk about trusts towards the end of the presentation, but if you create a trust and transfer assets to it, still it's subject to the 3-year look back. And any annuities you might purchase for the purpose of becoming eligible for this pension benefit would also be considered a transfer. Now, annuities are financial instruments or investments that reduce your net worth. With these investments, the veteran has typically bought them for the sole purpose of trying to become eligible for aid and attendance. There's a really big industry out there that sells these annuities to veterans. If you want to check out online what's going on, you can find all sorts of websites where they're selling these products. What they're trying to do is convert the excess money into monthly income payments in an effort to qualify a person for aid and attendance. So this rule has the effect of saying no more. We're not going to be allowing these annuities to be purchased in an effort to accelerate eligibility for medical assistance. Again, you could come forward and say, listen, I have an annuity, but it was not for the purpose of trying to become eligible for these benefits. So you've got to, again, rebut the presumption. So the interesting thing about this period of time that a veteran is ineligible for benefits is that the calculation is not based on the total assets that were given away, but only on those assets that exceed what is called the net worth. So if a veteran had about $130,000 and transferred $20,000, that amount above the maximum resource allowance would be considered a gift and might affect eligibility. So the maximum resource allowance is $123,600, so that's a $6,400 gift. Even though they gave away 20 grand, only $6,400 was going to be above the resource allowance. Therefore, that would be the amount of the gift that would be penalized. And the calculation of the time that you are ineligible is done at the time the gift is made. So let's say you made a gift, 2 years ago. It's the month following the month of the gift that the penalty starts. So if you gave away some money 2 years ago and it was a relatively small amount of money, you would not be ineligible today. And they calculate the penalty period, the time that you're ineligible, by dividing the amount that you gave away by the maximum annual pension rate as of the date of the pension claim. So right now, that monthly figure is $21.69. So if the claimant made a gift of $100,000 that was in excess of the CESRA, within the last 3 years, the penalty would be calculated by dividing $100,000 by $21.69, and that would be approximately 46 months of ineligibility. So that's a relatively long period of time, but imagine if 2 years ago you only gave away $5,000. Well, that's basically a 2-month period of ineligibility, not much more than that, and that time starts to run the month after you give the money away. So arguably with a lot of small transfers, the penalty would have long expired by the time you actually go to the VA and apply for the benefits. So that's actually a positive part of this gifting rule, is that the clock starts to run when you make the gift. And thankfully, the VA says, listen, if you made some gifts, you have 60 days following the decision that says you're not eligible to cure the transfer or partially cure it, so you can give the money back, and you have 90 days to notify the VA that you have, in fact, cured the gift. So it's not the end of the world if somebody still has the money and they can get it back to you. So start date for the new rules. As I mentioned, the rules are technically effective on October 18th of 2018, and nevertheless, by all accounts, the representatives of the local veterans offices are telling people that, listen, we're not really sure if those rules are going to start on the 18th or at some point in the future. We are being told currently it's business as usual. That the new rules have not been rolled out yet to all the local VA offices. So you need to contact your local VA rep and ask them, hey, are these new transfer rules going to start? I'm sending down a client, or I'm in a part of an assisted living facility. I need to know going forward, is this application going to be subject to a look back? What do I need to do? What about the new net worth rules? Are they applying them at this time? They may start with some rules and not with others. They may phase them in. So it appears there's going to be some delays in getting all the VA regions up to speed with the new rules. Nevertheless, if I had a client who might be applying for VA benefits in the future, I would tell them that the VA does have a look back, and penalty periods will affect any transfers that he or she intends to make. I just don't know when that exact date will be, but be careful about transferring assets. So one of the most significant changes in the eligibility rules is the limitation on exempting the acreage with your residence. So if you have a home and some land, you may not be eligible for aid and attendance in the future. As it stands right now, the VA rule will be a tough one to overcome. So transferring ownership of the home well ahead of time, before you need these benefits, makes a lot of sense. So if people are considering transferring the home or additional acreage, they may want to think about transferring to an irrevocable asset protection trust. This is a trust intended to protect assets from long-term care costs. I've done webinars on this before, so if you want to look up our webinar catalog, you can listen to a webinar on how these trusts operate. Essentially, they're legal arrangements to own gifted money or property. You don't have to transfer assets directly to children. You could keep them in the trust during your lifetime. And the money that is in the trust, or in this case, the real estate, is not counted when you go and apply for government benefits, be them aid and attendance or, in fact, Medicaid, that would pay for nursing home costs. Typically, family trusts, you're naming one or more of your kids to manage your assets, and the trusts do last as long as you are alive. It protects your assets from the kids alive, so they get divorced or have a falling out with you, have creditor problems. You don't have to worry about your home or your money being affected by their lives. And you can be protected in your house. The trust will say you get to live there for the rest of your lifetime. And you can also sell the house. If you want to downsize, the trust puts your house up for sale and the money stays in the trust. So that's one thing I think a lot of clients need to start thinking about, whether they're trying to protect a home from the VA benefits, or from being counted, if you will, for VA benefits or for Medicaid purposes. Start planning now. We do have 2 look-back periods depending upon the benefit that you're trying to qualify for. So if you're concerned about getting aid and attendance benefits in the future, now's the time to get a consultation. Plan ahead. That's my advice with all of these programs. Make sure you have the right estate planning tools in place that permit your loved one to take the steps necessary to qualify you for these benefits. Tools like a really good power of attorney. Not all powers of attorney are drafted the same way. You need a good power of attorney that allows the transfer of assets if you want to protect them. I see powers of attorney every day that don't have the authority to transfer ownership of real estate or other assets. So it might be a good idea to get that taken a look at by your elder law attorney. If you're considering transferring real estate, as I mentioned, you may want to investigate the asset protection trusts and how they might benefit you. All right. So if you have any questions, do contact Marshall, Parker, and Weber. We have a lot of great webinars on our website. A lot of great information on paelderlaw.com, such as blog articles or even on Facebook. So don't hesitate to visit our resources to help you through this process. Thanks a lot for joining me.